Yes, Your Honor, thank you. So, Your Honor, after the protective order was issued on Thursday at the arraignment, the defendant has made about 129 jail calls over approximately 27 hours of phone calls, and at least 9 hours of those have been to his children. The calls have been during school hours. They have been as late as midnight, 1 a.m., one night, Sunday night, one call as late as 1:48 in the morning. And these are consistent phone calls, 15 minutes that end, and then it's right back on the phone with the children. In some of them making comments about their mother May's family, that they are happy, that they were happy on Thursday, things that are disparaging to them. Asked his 11-year-old to read the headlines to him, asked to help calculate what the mortgage would be, and also I wanted to bring to the court's attention that in one of the calls he tells the 11-year-old that she and her 10-year-old sister should watch a movie called Shot Caller, which is a rated R movie that has warnings of bloody violence, and it's essentially a story about a businessman who goes to prison, and he suggests that they should watch it to understand the environment that he's in. So this is precisely the type of thing that this protective order is meant to protect these children who already have been traumatized by the loss of their mother, and he is constantly calling them, even after I spoke with his attorney, and she assured me that she spoke to the defendant and clarified that he is not to have any communication with the children, and during phone calls where he acknowledged that that's what he's being told. His parents tried to explain to him he cannot speak to the children, and he still cannot control himself and continues to communicate with them. So my reason for putting it on calendar today was to ask that the bailiff actually serve Mr. Millete with a copy of the CPO, the restraining order, here in open court, and ask this court to admonish him that he is not to have any communication with these children. No phone calls, no emails, no visits, no putting the phone on speakerphone so that he can have kind of surreptitious conversations with them through his parents. And unfortunately, his parents are having a hard time even controlling it, and they are actually assisting him in allowing him to violate the protective order. So I wanted to bring to the court's attention so that we could have clear admonishment here in court, so Mr. Millete, the defendant, has no misunderstanding about the court's order.
My understanding, Ms. Bowles, is he was served in court with the protective order. I read it word for word to him at the last hearing.
And yes, and so I don't mean to say he wasn't served. I meant with a paper copy so that I agree with the court that he was served, but I want to make sure that he has a physical copy with him. I don't know if he was given a physical paper copy.
I believe he was given a physical copy. Are you also, so at this time you're not indicating to the court that you're amending the complaint to add criminal violations of the criminal protective order?
I may be at a future time, but I also, again, just wanted to make sure it was very clear, because I know we also, I was careful because I did not want the children's names read out loud in court. So to the extent that there could have been any confusion, I wanted to just make sure it was very clear.
Secondly, are you asking the court at this time to order that his phone privileges from the jail are restricted, that he can only speak to his attorney over the telephone?
Well, I think that I think at this point that is, I will defer to the court on that, if that's the restriction that needs to be made. But I wanted to, at the very least, again, make sure that the admonishment is very clear.
And are you indicating that there were over 100 phone calls to the children?
Not over, there were 129 phone calls in total, because some of them are to his mother or father, and then the kids get on the call. I can't specify exactly the number of calls, and also because there's so many, I haven't been able to go through all of them in depth, but I could spot check them, and I can say that there are, and I think it's probably, this is conservative, but 9 hours worth of phone calls. So again, they are back to back to back to back.
All right, thank you. Ms. Martinez, did you
Yes,
want to
thank
give
you
her?
very much, Your Honor. Yes, I am actually somewhat comforted that we're having this hearing because it is not very clear about, I saw the documents that he was served with the restraining order. It was checked on my copy that counsel provided to me, but he said he never got one. So,
Ms. Martinez, he was present in court when I read the
yes,
criminal
I was
protective
here.
order. Don't interrupt me.
Right, Your Honor.
Word for word,
Yes.
which
and-
included that he was not to have any contact.
Yes, I was present, and that's why I told him he was not supposed to contact. He said he thought it was generally any witness, including, So I said, oh, well, he wanted me to get him a copy, so I requested Ms. Bowles to get him a copy. And now we're here, and I wanted him to be served, Your Honor. It's clear, and he understands the criteria that the court outlined in that restraining order. And I think he needs to hear it from you, Your Honor.
He did hear it from me.
Did you hear it?
I didn't know the kids were a witness. I didn't.
All right, well, let me reiterate, Mr. Millete. First of all, let me explain what a court order is. It's not a suggestion, and it's not a request. It's an order that you must abide, or you risk further criminal proceedings. At the last hearing, out of deference to your attorney, who didn't want your children's names read in court, the court specifically asked, through your attorney, whether you were aware that the orders that I was going to read applied to the protected parties listed on the document, who were your 3 children. I don't for a minute believe you didn't understand who I was talking about. But just to be sure, I'm going to ask that a copy of that criminal protective order be handed to you here in open court. Do you have a copy? Do you have a copy in your
Yes,
hand,
Your Honor.
Deputy? All right, that copy will be handed to Mr. Millete in open court. At this time, the court is going to order that Mr. Millete's privileges to use the phone through the county jail are limited to only his attorney. I believe, sir, that you understood what your orders were and that you violated them blatantly and multiple times. Anything further, Ms. Martinez?
Yeah, I'm contemplating on filing a motion for modification of the restraining order. If the court would grant me that, privilege or honor to file that, would I be filing it here in the court?
You can
Or-
file
or
it
Judge
at our
Moore?
business office, and if it's after next November 4th, it would be heard in Judge Mooring's department, so depending on when the date is given.
Thank you very much, Your Honor.
Ms. Bowles, anything further?
No, thank you, Your Honor.
All
Thank you,
right,
Your Honor.
we'll confirm next week's hearing, November 4th at 1:30 in this department. We're in recess and off the record. Thank you.
Thank you, Your Honor.